Well, hello, and thank you for checking into the online component for legal issues. Elsewhere in the world of issues, as you can probably tell from the sound of this recording, I am continuing to have some laptop issues where, in my mind, I think, hey, I should be able to plug this microphone into this laptop, and boom, we'll have a wonderful sounding online component. Where in the mind of my laptop, I think it has another idea. So thank you for your patience during this time. I think we're going to call it a pass, or a standoff anyways, between me and my laptop, and just move on. So let's get to the issues. And we touched upon a lot of them in class, and we're going to dig just a little bit deeper online here. But I feel it important to say once again that I am not a lawyer. None of this class should be taken as any sort of legal advice. This class provides a layman's view of the various legal issues surrounding podcasting. If you need legal advice, of course, you should seek out a qualified attorney. Now, as we know, a number of legal issues apply to how you conduct yourself online. Amateur or not-for-profit broadcasting or podcasting does not offer blanket legal protection, so you can't say, oh, we're just doing it for fun. You still have to adhere to some rules while still having fun. Now, our discussion is about Canadian law also. We talked about that in class, but the global nature of online communications means that other jurisdictions, that's a tough one, eh? Other jurisdictions' laws could apply. So, if you're speaking on the subject of rules of another country, you have to kind of be mindful and respectful of what's going on and how best to deal with those things before shooting out super colorful or heavy opinionated comments. It's better to be safe than sorry. And I mentioned that in class too, that a lot of how you should approach yourself in this manner is a lot of what you learned when you were young. Be truthful and respectful, and you're on your way. Of course, there's still some fun to be had, and people like to dance around the rules a little bit, so we'll learn about that. Now, defamation as a definition is communication about a person that tends to hurt the person's reputation. Defamation is a strict liability tort, which means that the intentions of the defamer are not relevant. I didn't mean it. I just meant this, that kind of thing. You have to be mindful of what you're saying and how it's going to affect someone. With that in mind, the communication must be made to other people. It can't just be you one-on-one and not just to the person that it's about, right? And the statement, of course, must be false to be classified as defamation. If it's true, then the person may not like it, but it's true. So there you go. If it is spoken, the defamation is termed as slander. If written or recorded, it's termed libel. Well done, hopefully. Now, the defense from defamation, as we mentioned before, truth. It's a good start. If it's true, then you cannot be defamed by something you are. Again, you may not like it, but you can't fight it. Absolute privilege. So we mentioned that in class too. Courtrooms, parliament, there's lots that go on in these arenas that are way more accusatory in nature, finger pointing, that in the outside world, outside of those walls, you'd get in, big trouble for defaming someone. As we mentioned in class, the prosecuting attorney that points to the defendant in a court of law and says, this man is a murderer, and then that man is found not guilty, that man can't then go to the prosecutor and sue him for defamation, because it's absolute privilege that accusation is part of that process. Similarly, in Parliament, you see a lot of yelling going back and forth between the parties, and especially now, actually, in the news with Bill Morneau and everybody up in arms about his actions and the call to have the finance minister resign. There's all kinds of things going on. And there was actually an invitation on someone's part, said, come outside the room. I will ask you these questions outside in front of the media and anybody else, and answer the questions there, because Bill Morneau is is threatening legal action of his own to get them to back off a bit. So it's really, we're in the thick of something very interesting at this time, but he hasn't, at the time of this recording, accepted the invitation to speak in front of cameras and answer the questions that everybody seems to think are not being answered. So that's an interesting time. That's absolute privilege as a defense for defamation. Qualified privileged would be the honest opinion provided to someone with a legitimate interest in hearing it. And we talked about that in class. The boss of an employee asking a question about a coworker, but it's for good reason, that the person is acting in good faith and without malice. They've been asked that question with a legitimate interest in hearing the answer to it. So it may end up affecting the person being asked about, but the person that answered the question is protected by qualified privilege because they were asked in that arena. Fair comment comes in editorials, freedom of the press, responsible communication on matters of public interest. There was a story a couple of years ago at one of the mass shootings, I think we talked about that in class, where a piece of evidence was found. It was a driver's license at the site, and they assumed, well, not assumed, they thought at that time it was part of the process of trying to figure out who the shooter was, and they gave the name of the person on the license as something that they had found. As it ended up being not that person, that person couldn't then sue the reporter for insinuating that it was that person. It was all part of matters of public interest. So fair comment would be yet another defense from defamation. So for publicity rights, this applies to the use of someone's voice, image, or likeness, like the artist drops that we hear on radio stations where they say, hey, it's your girl Rihanna, I love it that you play my music, and this is the place you're going to find the best music, and all that stuff. This is okay, right? It's sort of insinuated that the person, knowing that they've done the artist drop, that they've recorded themselves for that purpose. So they can't end up in Ottawa. Rihanna can't come to Ottawa and say, hey, what are you using my voice for? Because she's recorded it and thus given permission for its use. You cannot use aspects of someone's personality for personal gain without their consent. That's the important thing. She knows what she's doing, and we're talking about Rihanna here. She knows what she was doing when she's recording IDs like that they're going to be used in that way. But the trouble is that if you're using them in a negative light, they likely weren't signing on to have it used in that way. So for rights like that, like it says here, the exception is if they are the subject of your program. That's when, you can't normally use the aspects of their personality without their consent, but if they're the subject of your program, it's positive, and if it's taken on a negative spin, you're certainly putting yourself in a position to get in trouble. If it's putting them in a negative light, and it's probably not wise to do that. Now, copyright. This attaches to works once they've been fixed, so written down or recorded. Copyright gives the owner the exclusive right to control certain activities in relation to the work. Copyright owners have the right to exclude others from copying, changing, distributing, and or performing their work. They're the boss of their work. There was a format in Calgary, I think Ryan Lindsay worked there. AMP. Yeah, it was a quick hits format. And what they did, I guess legitimately, or literally rather, taking sections, chunks of the song out and really just shortening the song. So literally quick hits, because it took less time to play them, but it changed the song entirely, and they got in a heap load of trouble for it because they never asked permission to do that to those songs. You're not allowed just editing songs like that. You have to get the permission of the copyright owner in order to make any change. And if not, then whoops, you're going to get in trouble. So basically, in general, you need to secure permission. The copyright owner has that going for them. So if you plan to do any of what we just talked about in a format like that, it's a lot of work, right? So you're not just going to do it. You're probably going to work with what you have because it's all there. Now, moving on. We talked about photos, not just this week, but even before our a few weeks off from class. The idea is that you have to give credit where credit is due. So when it comes to photos for your for Facebook or anything that's not yours, but for social media, your best bet is to use original photos, something that you've taken, stock images, which you paid for, which you have access to through the station, or photos that you have expressed written permission to use. Seems pretty clear. And yet, people try to skate through the loopholes all the time. A better option, I mean, we're going best to worst here. So before best comes better, using the photos that are labeled for reuse in the Google image search. So let's go there for a sec. Let's go to the Google, shall we? Hello, Google. Let's go, and there we go. Let's look for Pink. Okay, she's in there. We've got her in images, and here we're going to talk about Pink and the tour and all the stuff. We're just going to use any old picture? No, we're not. We're going to go to Tools right here. The drop down, Usage Rights. You go to that, and look at that. You can search for photos labeled for reuse with modification or labeled for reuse. Those are pretty clear, right? Because then it really narrows the search somewhat into a safer zone. So if we were to go there, so those are labeled for reuse. Look, see how many we have. Well, don't look there. I just saw a bunch of things that didn't necessarily refer to Pink as the artist. So let's even go a little bit more specific and go to labeled for reuse with modification, which means that you can use a photo, put your logo on it, you can edit it for size, but they're labeled, so they're safe because they're in there as such. They've been filtered down that way. See, commons. So you're okay in a best case scenario with this. Not a best, but a better. Let's go to some of the okay options. Right? Okay. You can use a photo from another website, a media website, crediting the site and providing a link to the site. And we talked about that in class, just that it sort of not only gives credit where credit is due, but it, in a go the extra mile, it'll also benefit you kind of way. It creates traffic for the source, so that increases the benefit for them. You're using it for your reasons and doing something good for them at the same time. This is an okay option. Let's go and see what the bad options are. Using a photo with no attribution, no credit at all, just taking it, using it, and mic dropping it. You don't want to do that. You're putting yourself in a really bad position, and why would you? Give credit where credit is due. Your worst option, using stock photos you don't have rights to. And just when you thought it couldn't get worse than that, there's the nightmare, which is using photos from a professional photographer that are intended for sale. The photo of 24 Sussex, and we talked about that. The picture that wasn't going to be worth $1 million or anything, but certainly more than 1,000 words, $25,000. This was the photo that Boom used of 24 Sussex on a Facebook post from last year and a half ago. And let's just go there for a second. And it's interesting because that's not the photo that was used, and that's indicated right here. It was a different image that was taken by a local photographer who, based on the times that he had sold them before. The picture was sold. The Chatelaine, the photo that Boom used on their site for $450. CPAC used it for $350. So he determined, based on the number of shares that the Boom Facebook post got, which was in the neighborhood of 40, I think, perhaps more, that his potential for earnings had been diminished. So he determined that $25,000 would be something that would make it all better for him as the photographer who owned that photo. And so it didn't take long to figure it out. The following month, that local photographer, Paul Couvret, reached a settlement, and the monetary agreements were confidential, but he was satisfied with it. Now, there's the photo, and everybody's happy now. So see, there's his name. So you can't just use it and not give credit, because that was expressly indicated for sale, this photo. So that's where some trouble had come from. But it's better now. And now we've all learned. And I remember that situation happening from my own experience at my radio job, where it was like, yeah, we got to make sure that we're giving credit where credit is due. So it was, every company is interested in not paying out money when they don't have to. So this is an opportunity to be a good employee. Start by being a good student. How about that? So there are some instances, 5 in fact, where permission is not required. You don't need permission if you're using a fact, an idea, a theory or slogan, title or short phrase. If you're using works that are in the public domain. Now, there's an interesting story that's happening within the past week or so of that Calgary artist who was paid to create an experience. And what this artist did was take photos, and let's go look. If you didn't see this in the news, it's actually kind of interesting, because he had taken photos, as you can see here, and blurred them out and put statements on them. I sleep outside, I will survive, and others. And this, this world is small sort of thing, someone in Calgary recognized one of the people in the photos and said, I think I saw your picture. This person is in the UK. And it's a comedian named Bisha Ali, who's based in England. And this is how the whole thing got uncovered. Now, the artist, Mr. Besant, they received printout pages from a handout flyer. So he thought it was already in the public domain, which is why he felt it was okay to use the photos. And he's very sorry. And hopefully won't be too sorry, but I'm guessing that something will come for the $20,000 that the city paid for this not expose, but this exhibition, I suppose. Something will have to come of it, which is sort of interesting. But fair enough, right? Thought it was in the public domain, and this is one of the places where you are kind of okay to use stuff if it's in the public domain. So that brings us to our next point. Using works that are in the public domain. Now, if you're using a government work, brochure, report, or law, there's some gray areas there, but similar to this guy, this artist in Calgary, you'll want to be sure before you make any moves about using that stuff. Another instance where permission is not required, that you are engaged in fair dealing. So we'll talk about that a little bit more in a minute. And elsewhere, if you're using Creative Commons licensed or PodSafe content, which sometimes comes with the hope of attribution of credit at the end as publicity, which is like we talked about before, giving credit where credit is due, but PodSafe content. Again, what you're looking to avoid is just grabbing something and using it with abandon, like as if there's no concern. There's all kinds of concern. So making sure that your I's are dotted and your T's are crossed are it doesn't take long to figure out what you're allowed to use and what you're not allowed to use. Oh, what is fair dealing? Funny you should ask. Fair dealing is copying a substantial part of any protected material, so texts, sounds, images, things like that, for one of only 5 limited purposes: research or private study, criticism, review, or news reporting. And what that means then, if you're doing an audio thesis and you're using music, but you're using it for that purpose, research or private study, review of an album, review of a book where you can take parts of the book, lines from the book, a clip from a film, if you're reviewing a film, if there's segments of protected material under fair dealing when they're being used in the news for reporting. This is when fair dealing is when it's okay to use this stuff. Now, for music and podcasts, there's 3 layers of copyright in the song: the musical composition, which is the writing, the performance, that's the person performing, of course, and the sound recording, so the label that will be one of the 3 parties upset if you're not asking for permission to use their stuff. And for each of the 3, there are reproduction and performance rights. And these are protected by these collectives, SOCAN, the NRCC, so the Society of Composers, Authors, and Music Publishers of Canada, the Neighbouring Rights Collective of Canada, the Canadian Musical Reproduction Rights Association, SODRAC, which is the Society for the Reproduction Rights of Authors, Composers, and Publishers in Canada. So why is there a D in there? I don't know, but there is. Audio Video Licensing Agency. Basically, what you're looking to do, if you're looking to re-record a song or reuse a song, that there's compensation and copyright protection for all of that. And basically, all that means that they're protected, right? So there's all kinds of people with interest in the art that they're protecting, and all kinds of people that are going to try to protect that. And the reproduction and performing rights collectives do not currently issue licenses for podcasts, which is interesting, for using music in podcasts, I should say. Canadian law regarding SOCAN on the subject is actually pretty confusing, and surprisingly so, because they do have a regulation to collect royalty fees, but no license with a clear outline or mechanism to collect. What they have indicated, and I'm pretty sure it's at least 10 years old, this information, that in the case of amateur podcasters whose use of music represents less than 20% of the podcast's overall programming time, and where such podcasts generate no revenues, an annual license fee of $60 shall apply. But you can't find that license. So what's interesting is that SOCAN doesn't seem to offer such a thing for music-based podcasts, and they cover performance rights, not reproduction rights. So there would be something else to consider there too, which is probably where the gray area continues. I think the greater question is, why does this gray area continue? And I'm speaking sort of in my own humble opinion. How come it would take this long? Why can't they just come up with an equation to figure this out? As podcasts aren't exactly new. But music and podcasts, in conclusion, until such a time as there is an easy-to-use and affordable music licensing model for podcasts, it is best to use royalty-free or pod-safe music. So steer clear of that, of using music, because as we discussed in class, you can get a little tap on the wrist, if not more than that, and pleading ignorance isn't going to really help you out, especially since you're not ignorant. Now, remembering that if the music is incidental or if it is part of a criticism of the music, then it's back to fair dealing. But there are times where they may just be trying to make a point of or send a message, that kind of thing. Don't get too confident where you're using the music. You want to be clear that you're allowed to use it, and clearly they're not clear with what you're allowed to use. So keeping it to the pod-safe stuff is best. Talking about the music, that's good too. And maybe considering a job in a legislative area where you could come up with the answers as to why can I find a podcasting license. See, there's a future for you. Thank you very much for your attention today. Appreciate that. I hope you're having a good week, and I'll see you in real life on Monday. Bye.